So therefore, humility.
7 minutes past 2 from the studios over the by 8.9 FM. Good afternoon and welcome to today's edition of Agenda Setting. My name is Major Daniels and I've been joined on the program this afternoon by legal practitioners. Let me welcome Mr. Femi Modamore. You're welcome on the program. And Mr. Shola Ajishafe, both of them, like I said, are legal practitioners, because on the program today we'll be discussing judicial reforms. Of course, you know that agenda setting is all about setting agenda for the incoming administration of Bola Ahmed Tinubu. So today we're looking at judicial reforms. You're welcome on the program.
Thank you very much.
Thank you.
So let me begin from Barrister Shola Ajishafe. One of the things, if you look at the manifesto of Bola Ahmed Tinubu, if you look at page 65, which talks about judicial reforms, one of the things that jump at you is the proposed establishment of a review committee that will make recommendations on reforming the structure of the judicial system. Now, let me ask you, what kind of restructuring would you like to see in the judiciary to make the court function more efficiently and then devoid of corruption?
Well, thank you. What you have said now presupposes two things. One, the structure of the courts and the judicial system in Nigeria, and then the innate issue of corruption. So let me take it one after the other. Now, when you talk about the structure or the entire gamut of the judicial system, one will be looking at the various aspects. The judiciary is a separate organ of government, but within it you will find other areas. We are lawyers here now, but in the process of becoming lawyers, the federal government is equally involved. The Supreme Court is involved. The federal government is involved in our training. Having left our various faculties of law, we went to the law school. Leaving the law school, the Supreme Court has to certify us fit and proper for us to practice in Nigeria. We are given a roll of honor and a code upon which we are to practice. That's one garment. There is the area of the ministries, the various ministries.
Of
justices across the state. What are they doing? Then looking at the court itself, the structure of the court, starting from the customary courts or all those area courts, then to the magistrate courts, then to the high court, and then court of appeal, and then the Supreme Court. One thing that we have been able to discover is that the ways and manner the court in Nigeria is structured has affected the delivery of judicial benefits to the Nigerian people. First of all, if you want to appoint a judge now, the governor of Ondo State or the people of Ondo State could not on their own say this is the person we want to employ to work for us as a judge. There is still somebody there in Abuja who does not even know how the court system in Ondo State runs. They have to determine the number of judges that could be appointed at any point in time, not looking at the problems, whether civil or criminal, that is happening in Ondo State. Somebody will have to determine it. Then even the payment system.
That's the NJC. You're referring to the NJC, okay?
The payment system equally, it's basically not in tandem with the job these people do. And when you look at the whole gamut of this, you discover that a structural dial must be used to go through the whole system. When you look at people who work in the various ministry of justices, what are they doing? Is what can we say that what they are being paid is commensurate with the job they are doing? Can we say they are doing the job as it's supposed to be done? These are areas that we have to look at. Then in the dispensation of justice itself, when a judge has to handle about 30 to 40 files per week, aside from that, Look at our Supreme Court. Look at our Court of Appeal. Some of us have advocated, and I think Chief Gayani Fayemi has been saying it even before he passed on, that they should decentralize the judicial system. Look at it. As I speak, I don't know, my friend will have been in the court of, the Supreme Court of recent. You discover that the cases that are being handled in the Supreme Court today now could be that of maybe 2003, 2008. That the Supreme Court is actually looking at currently. Some of us have said, why is it impossible for us to have the Supreme Court just like it's done in the United States?
At the state level.
At the state level. No, let's say even at the zonal level. Geopolitical levels. The cases that will only go to the Supreme Court are maybe constitutional cases. Or the one, because yesterday now I listened to that.
For instance, like the naughty issue of FCT, which is being.
That one is just people are trying to be mischievous because there's nothing to discuss in that area. But people will just politically, this is a political season. People will just talk. But like yesterday, Agbakoba raised an issue. He was talking about, is it impossible for the Parliament, after the Supreme Court will have taken certain decisions, then is it impossible for us to revert it back to the Parliament to do some kind of judicial review? And I was wondering, a man of that caliber, because, and the reason why he's saying that is that so many things have been happening at the apex court these few years that makes it people not to have too much confidence in the judiciary or the apex court, as it were. But for me, anybody that wants to be the president of Nigeria will have to do something, not only in the judiciary, but since we are talking about the judiciary, we have to look at the constitution itself. All those powers that are given out, donated to some quasi-judicial powers, and then some powers that are given to the courts that ordinarily could be handled administratively. They have to be shared, and then let the court face the reality of what they are supposed to do, starting with appointment of judges or justices. Why is it impossible that for us? We have seen it in this country. Elias became the Chief Justice of Nigeria from the classroom. Why is it impossible for us to have somebody, lecturers and people like that, to come to the? Why do we have to wait for one principal or supervisor in Abuja before you can bring people upstairs? And you equally look at it too. By the time people who have the intellect, the capacity to become Chief Justice or get to the Court of Appeal, many of them are already old. And because of that, we just gather certain people. If you know somebody, if you don't know somebody, you are there. So for me, I will say that Asiwaju will do the Nigerian nation a lot of good. And maybe the legislature will have to do a surgical operation into the constitution and equally deal directly. Where there is the political will, then you'll be able to do such thing. If you don't have the political will, I'm sorry. And I believe that Asiwaju has that political will.
Okay. Okay, let me turn to Barrister Emodamore. Now, before I go on to another question, same question. What kind of restructuring would you like to see the Asiwaju Bola Ahmed Tinubu administration do in the judiciary to make the court more efficient?
I think Barrister Ajishafe has touched some of the major points I would have loved to raise. I can only expatiate on that. Well, let's take the bearing from two provisions of the Constitution. Section 17, subsection 2, paragraph E of the Constitution, which states, and I quote, "The independence, impartiality, and integrity of the courts of law and easy accessibility thereto shall be secured and maintained." End of quote. Now we are talking about independence. Well, we have the statutory independence, fiscal independence, we call it financial autonomy. Thank God.
What about restrictive independence?
That has now been signed. At least we have the law.
Yes, signed by the president.
That is.
But what about administrative independence?
Yes, we will talk about that. That is in terms of financial independence. In actual fact, no arm of the government is completely independent of the other. We are talking about appointment, but whichever way, I do not think in terms of appointment there's any really serious thing that we need to blame the involvement of the executive arm of government for, because even in the United States, you find that the president could single-handedly nominate a judge of the Supreme Court.
Yes.
And of course, in doing that, we'll always go for somebody who has the kind of psychological leaning, Now, independence, impartiality, and integrity, they are things that are quite, innate. They are not things, they are internal to the person of the judge, the person of the judge. Again, the appointment process is not about the involvement of government, but the scrutiny of those who make it to the judge. What about their background? Just like some very sensitive law enforcement agencies know. Did you properly screen those who eventually came? What is their background? Have you subjected it to serious? No.
Did you do psychiatric evaluation? That's some of the things that are done in developed countries.
Agencies involved, just like you are going to be holding a very sensitive security post, you are bound to give them, even voluntarily, download of yourself, everything you have done that's likely to, you must be honest to. I think we need more of men of integrity. This one has nothing to do with money. A judge who is going to be corrupt will be corrupt no matter what his salary is. It's just like a multimillionaire could still be corrupt. It's not as if money is never really the reason why some people just do it. They just do it and they never get satisfied. That's in terms of integrity. Then you also go to the provision of Section 36 talking about the right to fair hearing, and I think that is where a lot of Nigerians have problem. Cluster of cases in court, delayed in hearing of some cases, except now we have the political cases that the politicians have made law, stipulating the time frame within which you must decide. Every other thing, of course, have to suffer delay. I think this is where Nigerians have problem. They have lost a lot of considerable, passion for that arm of government. Their cases go to court, interminable adjournments. And here, in terms of restructuring, there are some fundamental suggestions I think I have. One, we need to amend our law. Not all cases need to go to the Supreme Court. That is just the basic truth. How, for God's sake, would you allow divorce case to get to the Supreme Court? I married my wife and my wife says, look, I'm not doing it again, and then we drag from the High Court to the Court of Appeal to the Supreme Court. We don't need that. I do not even think we need to allow Supreme Court to bother about things like chieftaincy and maybe land, but maybe lands will even be removed. Basically, things that states have the legislative power on should not be things that were allowed to go to the Supreme Court. If states should be allowed to have their own Supreme Court as the final court on those things, so be it. So, some people have advocated decentralization of the Supreme Court itself, like Barrister Judiciary said. Each state should have a branch of the Supreme Court. In that case, we have to amend the constitutional provisions stipulating the limit of the number of justices to be appointed to the Supreme Court. But we need to drastically increase the number of justices of the Supreme Court.
Well, what about digitizing
the
courts? Okay.
That is, we are still talking about delay. Number one, because if you are digitalizing the court and the manpower is not even there, if you have 50, you digitalize courtroom, then the manpower, if the constitution said you have 21 justices of the Supreme Court, and you know that no matter how digital the courts are, there is no way they can meet up. You just have to increase the number or decentralize, whether on regional basis or on state basis. Then limit the number of cases that go to this court. That's number one. Sir, you have touched on an important thing. The courts must go digital. Most of our judges, except if
they still write in longhand.
Pilot test in Lagos and now FCT High Court introducing that, they still write in longhand. You don't need that now. You just have to employ modern technology, get good stenographers to help them put down, record of proceedings, and then those records will be obtainable soon after you rise. I mean, those applications are not as difficult as they used to be. On your smartphone, for instance, there are icons you could press and speak into it, and then it translates. What you are saying is the same software they used to develop some of these things. Though we need to digitalize our court for effective justice delivery system. Then, that is that. Having talked about these two, let me say that we also have to encourage them by increasing their pay.
Okay.
I have said that no matter what you pay a corrupt person, you'll be corrupt. But you must also accept the fact that we need to avoid some unnecessary temptations. We think judges are well paid. Yes, they are. Maybe a high court judge, for instance, at the end of the month, with all the allowances, traveling and all that and whatever you call it, may go home with about 1.5, let's say maximum of 2 million. We don't have to talk about some things here. My dear brother, is grossly insufficient and ridiculous considering the reality. The reason why politicians don't complain about their own pay is because they have so many other places to look to. But judges are not permitted to do the same. A senior advocate of Nigeria would take a case, for instance, and has no limit to what he could charge. A very good big brother took a case from one of the neighboring state governor about 3-4 years ago. In fact, EFCC had to try to confiscate his account that they wanted to know the source of these. And he said, look, you found 75 million naira coming from this man to my account and you are confiscating it. It's a fraction of what I charge him. That I actually charge him 250 million naira for a single case. Now, if a judge earns 2 million naira per month, a whole year, he earns how much? 24 million. 2 years, 48. 4 years. So a single lawyer will earn from one single brief what it will take judges 10 years. It's not as if judges are inferior. The same training is just an individual discipline. You have chosen to go to the bench. Some have chosen to be practicing lawyer, while some have chosen to go to academic as professors. And then you find these lawyers appearing before you. You are colleagues. There are places you meet when you leave the country for holiday. The temptation is there. I think it's too low. It's embarrassingly low. So you increase the pay, digitalize, decentralize the Supreme Court, and make sure the kind of cases you allow lawyers to just push to the Supreme Court are reduced to the bare money. And the last, lawyers must be punished for frivolous cases instituted in court by awarding costs personally.
We'll get to that. Let's move on now. Now, one of the things in Tinubu's manifesto, he mentioned that some laws are outdated and that they're not suitable to modern day realities. Now, let me ask you, Barrister Modamori, which laws do you think fall under this category, and what reforms would you like to see put in place in this regard?
The truth is that if you comb our law, there are many of these laws that you wouldn't even believe exist. You will say ignorance of the law is not an excuse. That ignorance of the law is not an excuse. But for me as a lawyer, even with my very humble years of practice, there are many things I take laws that I don't even know. You may not even know they exist. Is it that laws are implemented, or if you think the society do not want or they don't reckon jettison this law? Of course, there are many. We will not be able to sit down here and begin to talk about those things. But for instance, just let me take an example of something there are dogs law. You have dogs law. For instance, in laws of Ondo State, you have burial law. The dog, you just walk around and then, you know there are laws regulating those things. We don't even seem to understand. There are burial laws stipulating what must be done before anybody is buried, stipulating where people must be buried, stipulating the offense that anybody will commit as a cleric presiding over when you have not complied with what. It's not even only during COVID-19.
But people are not aware. They have knowledge of these laws.
There are so many of these things that are just the junk laws. That's number one. Then there are laws that would not seem to meet the current reality of what we are talking about. For instance, you have laws made as far back as 1912 stipulating punishment in spite of the review of some very serious offenses, 1,000 naira. How? So we need a whole set of reform of our law. There's Law Reform Commission actually, and their duty, with all due respect, is to be looking at these laws periodically. Government have the institutions in place, but I don't think some of them are doing what they need to do. So the structure are there to make sure these laws are, constantly evolving and the evolution
to
of
ascertain
law
the
catches
workability
up with the current reality, and we now have what going digital. There are some of our laws we just have to flow. For instance, we are trying to make some of these court rules to accommodate virtual hearing. Before now
Yeah.
it was wrong, but today you don't have to. You could have a witness in US, you could have a witness in UK. As long as the court establishes the identity, why don't you take the witness on video? Some want to file for divorce.
Sorry to cut you. Do you have witness protection in Nigeria?
Well, of course we do.
Okay.
We do. We have such laws. Of course, there are very recent laws too.
But there's no rape in marriage in Nigeria.
Well, that would seem to be a kind of deviation. But I'm sure an average modern lady, the Beijing type. I tell people, you call me human rights activist. I don't call myself human rights activist. You call me that. That's all. But when it comes to family relationship, I am a very conservative person. Very, very conservative. I will tell you, I'm not an advocate of Beijing thing. I'm equal to my man. You can say anything you want to say, but you can't be wiser than God. So you are talking about rape. That's another interesting thing. But I think
that's just by the way. I just wanted.
When I think on a very serious,
I know there's no law.
Yes, I know on a very serious note. However,
but rape happens in marriage.
If it becomes something against the consent, because you can't put somebody in a kind of psychological trauma and say, okay, whether you like it or not. I mean, it could be something else.
You could rape your wife.
So
yes.
I want to believe in modern time we could say yes, there is rape.
Okay.
We could. Religious people might not like, but that's a very humorous digression anyway. We have a lot of things in our law that are not catching up with the modern reality. We just have to look at that. A lot of things we have been saying that. For instance, we are talking about grazing roads, for instance. Recently, we are talking about grazing roads. That there used to be a gazette of the federal government creating grazing roads, and some people relied on that. But in modern reality, does it? There are a lot of things. There are just too many in our laws. There are more laws that we don't even know about as lawyers that are there, or we don't make use of than the ones we actually make use of. So, but these things are not really about the federal government. A lot of states also have a lot of things to do in this regard. So, the laws are there. The ones that we don't need, we have to. The ones that seems to create a kind of punishment that is inadequate in criminal cases, we have to. The ones that seems just to concentrate on the imprisonment, custodial sentences must, if it has to be more fines. Sorry, sir, Mr. Dineji. Okay, law stipulate offense of either 5 years imprisonment or a fine of 100,000. It makes no sense. 100,000 naira for 5 years. We are not serious. We are not serious. The husband of a prominent person, a prominent politician in UK recently was caught for wrong driving or reckless driving. I don't want to mention that. Paid heavy fine in dollar that if you translate it to Nigeria, run into millions. The husband of one of the top 3 in UK government. Just about a month ago. So even our punishments, we just focus on send them to jail thing. There must be some kind of look. We have to move forward.
Okay.
We have to move forward. So
okay.
A lot of our laws are not catching up with the reality. Even things as simple as filing. My colleagues may have problem with this, but I have always advocated it. Oh, yes, easy accessibility to the court service secured and maintained section 17 subsection 2 paragraph E. Or what we pay to file in court is still ridiculously low. I say this. My colleagues don't agree with me. Now you are filing a whole case, you are asking for millions, and your lawyer is asking you for 1 million, 2 million. Or you may be surprised that we may not actually pay more than 10,000 fine. Now, judiciary is not to make money, but we are going in such a way that it's not supposed to be a profit-making thing, but it's also supposed to be at least an agency that is not too heavily subsidized. Something is
self-sustaining to an extent.
If you are talking about autonomy, so there are things like that we must, of course.
Okay, Barrister Judiciary, and talking about corruption in the judiciary. What reforms or body you think could be put in place to ensure proper monitoring mechanisms for would-be corrupt lawyers or judges to ensure that they are properly monitored and properly punished?
Thank you.
Beyond the NJC.
I think we have situated.
How do you think they can be effectively monitored?
Those are the things we have just mentioned here. Number one, if we go digital, the interface between people, I mean the litigant, the judge, and the lawyer, if we reduce it to a minimal level, we have a reduction in corruption. As a practitioner, I know, just like my friend said, let me use that area of payment or filing of cases. For example, the OB and Article 5 their cases at the Supreme Court. If you look
at the Court of Appeal.
At the Court of Appeal. But they pay just 12,000 naira and 16,000 naira.
Presidential election
Yeah, the filing
tribunal.
analysis of one of the process was actually 4,000 something.
Exactly.
And their lawyers will charge hundreds of
millions. So if you look at it that way, and there are so many people, that is not, if they get 12,000 naira, the one that went under, I know it, and my friend know it, the one that will pay, people will demand from us for a meter, for this thing. There is this way they used to catch us. You have to go to the bank, you have to do this, and you are paying 10,000 naira for something, and somebody is saying you are going to pay 35,000 naira. Those ones are not received. But you cannot, because you know that when you get to the bank, you know why it takes you to go to the bank, run scatter, at this period of fuel scarcity, and somebody is waiting for you in the office. You just look at it, okay, please let me pay, and then the 12,000 naira, it is the 12,000 naira that will reflect all the 10,000 naira. But the other one is for a meter according to them. That's number one. Then we have equally mentioned, what does a judge take home at the end of the month? Looking at the type of job they do, you discover that it is pittance. We must understand that it is pittance. So for this, we have to do an amendment or an increase.
You have not touched on, the question is, how can they be monitored?
Monitoring, well, we
to
have
check who is corrupt, who is not corrupt?
Well, that one are from two areas. One, the change in the value system. Like he said, a man who will be corrupt will be corrupt. That is given. But to monitor a judge, it is the role of society to monitor, because today, as it is now, as a practitioner, I know I have personally returned 2 files to litigants who have come to me and was talking to me about this, but these are not issues. 22nd years in practice, I've never approached a judge or whatever, anybody on the bench, for any favor other than doing my job as a lawyer. The law does not require me to win every case. But when the litigant wants you to go and help him approach a judge, and that is not having enough faith or not enough belief in you or in the judiciary. What I have to do is to, sir, can you take your file? There are many lawyers outside there. Go and meet them. But for me, I won't be able to do this. So what I'm saying in essence is that the value system will have to change. We have to look at the way we relate with litigants. And then what does litigants have to do? Then you look at like what happened some 3 years ago, where people have to go ahead to go and invade the houses of judges and justices. For me, I think that is not too good enough. I believe definitely that to monitor them, you cannot go illegal by trying to monitor a judge at that level, because that will have a way of killing the judiciary and reducing the belief in the judicial system and our judicial architecture. For me, the greatest thing I think could be done is that those who are found guilty, and there have been many like that, who are found guilty one way or the other, should be punished. For example, I know when Justice Kayode Esho, there is a Justice Kayode Esho panel that sat and came out with certain studies or certain recommendations. Those recommendations are still lying down wasted. How many of such are on our shelves today? If you look at it, the way people are brought into the judiciary, particularly the bench, the way there are political accrumature, if I can use that word, upon which people are brought to the judge. Many of these people, whether in the police, whether in the court, if I'm a lawyer, and myself and Femi are in the same classmates, we are classmates in the university. If it's on the bench and I'm in the bar, when issues come, what I'll be able to do, except will be reduced. If, God forbid, there have been cases where lawyers are found to have done one thing or the other, even senior advocates, we have seen it. And there have been cases where judges have infractions with the law. But how many of them have found their ways to the backyard? No. And if there have been any. So managing or trying to checkmating them is more value system change. And then the institutional development, which the NJC, you cannot take it away because you cannot punish a judge in Nigeria today. The only organ that can punish a judge is the NJC. And it is to punish lawyers, we know the people that could punish lawyers. So it is the value system that has to change. Do not forget that lawyers are not angels. Judges are not angels. We are part and parcel and we are products of the society.
Okay, because of our time, let me move to Barrister Modamore. One of the things that stands out in Tinubu's manifesto is a proposal to limit the mandate of the NJC to only federal courts. Is this a good move?
It is.
How so?
In fact, earlier when you talk about some of the reforms one would contemplate, I had wanted to equally mention the fact that irrespective of the reservations we might have, appointment of state high court judges will be restricted and limited to states. If a federal body has to approve or recommend the appointment of a judge that you call a state high court judge, we are still operating a kind of unitary system of government in the name of federalism. It shouldn't be. So you talk about NJC limiting itself.
Its mandate to only federal courts.
Yes, I agree. In terms of appointment and discipline or promotion of judges, it should be restricted to federal. Let the federal agency deal with what is federal, let state agency. We fear abuse sometimes, just like we all fear the abuse when we are talking about state police. Those concerns are legitimate because if you look at the desperation of some political actors, the state seems to be closer to the people, so they look at actors in the state and if this person is behaving this way, if he has the power to do this, but the truth is that abuse also happens at the federal level. So I think the NJC should be limited to federal court, like I said. Even in terms of recommendation of appointment of judges, it should be to federal courts. Let's have a similar agencies at the state level to deal with discipline of judges at the state level. In doing so, number one, you fast track the process of discipline, and then you fast track the process of appointment. You also, a lot of things will be accelerated in that regard. But still talking about the question you asked later, monitoring some of these things. It's a little bit difficult. The whole society, one thing rubs on the other, because like Mr. Yusafe has rightly said, judges are not angels.
They are part of the society.
Amongst the people, or We must, however, be honest to admit and, in fact, commend judges who still hold their head high. They are. And one of the greatest critics, sometimes I could be very fearless when I find some things that I need to complain about in the judiciary. But I have a lot of respect for some judges that I personally know that they are corrupt. A judge in this state, for instance, about a year ago, had to, in the open court, give a very damning judgment against a party, and at the end of the day had to disclose in the open court that, look, well, I've just delivered this judgment, but gentlemen, something happened, and then I don't want this to repeat itself, and mention an attempt to influence his judgment. You know what? This judgment was against his in-law. Because if we are condemning, we must also commend. There are so many like that. Absolutely. One has been elevated to the Supreme Court now. They may not be angels. Sometimes they make mistakes. Sometimes we get judgment, of course, against us before them, and we have reason to think I'm going to appeal. But sometimes some of these judges, they are still there. But if the good ones, for instance, are like this, and they have no money to throw around in attending the burial of senior judges or some of their contemporaries who sit in some of these bodies where promotion are done, and through certain things like some of their colleagues who take bribes could do, and so when it comes to promotion, they still remain where they are, just like officers, police officers who decide not to be corrupt, who will not be posted to some quote-unquote juicy, post also. So we must promote. When we find integrity, let's celebrate it. Nigerians do not celebrate integrity anymore.
Okay.
That is financial corruption. Corruption comes in other ways. Spiritual leaders. He's the church pastor. They will go to any length. So it's not everything that is even money.
Yes.
Those who can put a lot of pressure on you, sometimes not money. So you talk about control. Digitalization will also help. Like I say, I think eventually this cashless thing will also help. But security agencies must be on their toes to monitor.
Okay.
Must. And then when we find it, and of course lawyers, of course, sometimes contribute to this. Judges don't invite people most of the time on their own. Come and give me money. Certain people find a way to penetrate who is close to this person.
Yeah.
And our senior lawyers, those who carry the title of senior advocates, will do more.
Okay, so moving on. Earlier we talked about talking about the congestion trial courts. Some people have said that there should be specialized courts, more specialized courts, that this will help in decongesting trial court. Barrister Judiciary, is this something you would agree with?
Absolutely.
What sort of specialized court do you think you would love to see introduced?
Okay, let's start from here. Before in Nigeria, we used to have the regular courts handle election matters. But today, it will seem that election matters are handled on its own. But even though we still bring people from the regular courts, like Emoda Amori said, so many things will have to stand still. I think we should do better than that. At a point in time in this country, there are tribunals of armed robbery tribunals and the rest. In Lagos, there is a corporate court where issues of that has to do with commercial matters are treated. As it is, I would suggest that certain things should be done. One, if you go to Lagos, 80% of cases in Lagos are land matters. If you equally come to Akure, I may be wrong, most of the issues that happen in this jurisdiction are land matters. You have very few commercial issues. So for me, certain things, if you equally look at the area of child relations and marriage and the rest, we should prioritize
family courts. Okay.
We should prioritize this area so that people will get access to justice early enough, particularly in the criminal areas. Because you see most of if you get to the police today, most of those people who are in court, who are in in the police stations are people that are just kept there. If you go to Olokuta today, 80% of people that are there are awaiting trial. Olokuta is 10 times above its capacity. People who are supposed to be there. So, and I think the Ondo State Judiciary at a point put a court, or either one or two, can't remember now, in Olokuta, where people have to be to assist in the dispensation of justice. My own one thing that I would say to reduce this, more courts have to be established. I mean, in the same jury, like the High Court. The High Court in Ondo State should be expanded, and the same thing across the board. Magistracy, because there are so many people who are out there who wants to come to the bench. For example, in Ondo State now, we are given just a quota. As I speak now, if people are to be appointed, I know that there's a process to appoint new judges now. And how many? Just 4. Whereas there are so many areas that when you look at what judges look at every time. Okay, the last time I was at the Court of Appeal, I saw the number of cases before those 3 men. Each day in the Court of Appeal, they do not treat the number of files that will be brought for them is not less than 50 or 60. These people are not superhuman. So one of the things I would suggest is that there should be expansion in the number of courts.
Okay.
Then increase in the number of people that are brought to the bench. This will provide opportunity, and equally, particularly in the criminal aspect, I have said it, and a lot of people have said it, allowing police to prosecute in the magistrate court delays cases. The police prosecuting in the magistracy delays most of the, and keeps a lot of people in prison. Then in our various ministry of justices, those people that, because that's another important area, those people should be encouraged. Bring in new lawyers, expand the capacity to do the job, and give them what is necessary. If you give people who are in the bench something to do, those who are in the other bench should equally be assisted. They should be encouraged, because they are the one who go to court for government. They should be should be assisted.
Okay, Barrister Jishawe, because of our time. Barrister Modamori, I'm reading this from page 67 of Tinubu'S manifesto. Those judges with histories of excessive delays, improperly or carelessly granting ex parte injunctions and other questionable practices will not be promoted and will be liable for sanction. Lawyers who engage in such practices will face the professional disciplinary process and sanctions as well. How would you react to this statement?
To some extent, that is reasonable. Let me start with lawyers before I go to judges. Some lawyers contribute to delaying cases. And some of these things may not even be deliberate, but then a lot of times we ask for frivolous adjournments. However, judges are supposed to take charge of their courts. Criminal trial, for instance, already has a statutory limitations in terms of adjournments. Under the Administration of Criminal Justice Law of Ondo State and under the Administration of Criminal Justice Act of the Federation, there are limited number of adjournments any party could ask for. If judges are fair, if judges are fair, it's on record you have asked for this, it's on record you have asked for this, no longer granted. We must be fair. Let me commend one of our judges who has now moved to the Court of Appeal in Ondo State. And we have a lot of judges like that, but I don't want to commend the ones who are still at least at the High Court level, because it will be taken that you are here, you try to, curry favor by patronizing. Honorable Justice Adequate.
Of course.
And we have a lot of judges there now. One wielded a big stick against me last week, although to no fault of mine, I wouldn't mention that. If you are before Justice Adequate as a sitting High Court judge here, you must be ready.
Okay.
You must be ready. Bring all your witnesses, I must be ready. And if you adjourn, he may say, it's okay, don't worry. Let's take 3 like 4 days. We know these cases are coming on all these settled days. If for any reason the court cannot sit on any of these days, you automatically know the next adjourned date. Look, trial schedule is something that the judge, the court, and lawyers will interact with, and this is the trial. You don't call with 4 witnesses to come and repeat the same thing. You call one, or you at most you list 2 in case one cannot be there. So, I think judges should be fair. So, judges who have history of delay in their cases should be held responsible because, honestly speaking, they wield a lot of power. They take charge of their court. A lawyer is giving one excuse and not feeling fine. Look, after 1 or 2, if you are not, then you let another person take over your case. So judges must be firm. Then you are talking of ex parte. That's a very delicate area. Sometimes ex partes are necessary. So at what point would you say some judges who grant questionable ex parte? Who determines how reasonable the ex parte is? Who will determine? For instance, we had the Naira crisis thing and then people had to run to the Supreme Court and the Supreme Court granted ex parte. Whether it was reasonable or not depends on your own point of view. And I, Femi Emmanuel, was one of those who supported the Supreme Court. It was reasonable. But somebody else felt, look, that ex parte injunction was not necessary. So who determines the reasonability? So in exercising discretion, I think we must also be very careful. That is in terms of granting injunction, whether ex parte or interlocutory, except we can establish other extraneous factors that influence the judge in time of, corrupt practices or patronage. I will not support that part of the manifesto. But judges with history of delayed cases, there's no point promoting them. I think I totally agree with that.
Okay.
Because you should take charge of your court.
Okay, 2 more questions. Because of our time. One to Barrister Ajishafe and one to Barrister Modamori. And now, to Barrister Ajishafe, one of the 16 bills just signed into law by President Muhammadu Buhari is the movement of prison to concurrent bill, which means that state government can now establish their own prisons as we have in places like the US. What do you think about this? How do you think this can help with the administration of justice? Then Barrister Modamori, let me read this to you. Section 130, subsection 1 of the Electoral Act 2022 states that no election and return at an election under this act shall be questioned in any manner other than by a petition complaining of an undue election or undue return. In this act referred to as an election petition, presented to the competent tribunal or court in accordance with the provisions of the Constitution of this act, and in which the person elected or returned is joined as a party. Now we have people protesting on the streets across the country. This is what the Electoral Act. To what end do you think this protest? It will go by what this act say. Can we say that these protests are legal? So, Barrister Ajishafe, let me start with you. The prison.
Well, in 1963, Nigeria became a federation. Even though we have been running a quasi-federal system of government. Like we said, we were asking the reforms that are necessary and we talked about the constitutional destiny. After some time, I found out there are 69 contradictions in the current 1999 Constitution. Areas that are supposed to be left to states alone.
Because of our time, let's talk about it.
So I think, for me, that's a fantastic step. Why he's doing it at these wee hours is not something I can contemplate. But I think the state should be allowed to take certain steps and regulate their system and do those things that are necessarily supportive of their being CEOs of their various states.
Okay, by some other matter.
Let me say that I was in Abuja last week and I was head up in some of the protests. I was at the Federal High Court when some people protested to INEC, and there was also another protest.
And then to the Court of Appeal.
Yes. It is true we have the fundamental right to freedom of expression enshrined in Section 39 of the Constitution. It is also true that we have the right to freedom of to assemble freely enshrined in Section 40. So they assemble and then they said they are expressing grievances. But like I always say, fundamental right without any form of limitation is another definition of anarchy. What were you expression? You gather together, apart from what you call a presentation of a petition to the tribunal which I addressed, and you are calling for certain things that are totally against the Constitution of the Federal Republic of Nigeria. Section 1, subsection 2 of the Constitution says that, look, no bodies are take control of the government of the Federation or any part thereof except in accordance with the procedures stipulated in the Constitution. I know we were fighting the military in Nigeria and this consent of sovereign national conference and then the interim government and those things became part of our political nomenclature. But it is totally an aberration. It is totally treasonable for anybody to call for the government of the Federation or any part thereof to be taken over or to be constituted other than the way stipulated by the Constitution. And I think certain people have taken their luck too far. That's number one. You are talking about presentation to of petition to the election petition tribunal. Yes, that is true. It's provided for in section 130, section 134, like you said, of the Constitution stipulate the grounds for petition. Election petition tribunals are created by section 285 of the Constitution, and I think it is totally unfortunate for me, for anybody to have contested an election pursuant to the provision of the Constitution, offices created by the Constitution, and then turn around to say, look, I don't believe in the procedure created by the same Constitution.
And they're already at the tribunal.
Yes, and then you are the tribunal. I think it is totally uncalled for, and I think we should be careful. I always say we should be careful because I was not too young to know that in 1993, this was how some people, anti-democratic forces, started. But this may be a little bit different, and we have to just sound this note of caution, because if certain people say, well, if it is about popularity threat, we can also mobilize and we invade the FCT or any part of Nigeria to also protest, I'm sure you know what that will lead to. And I think the security agencies have been diplomatic. Otherwise, they know this is a criminal offense. This is a totally criminal offense, but they must wake up. Otherwise, if you allow this to continue, it's unfortunate. And I'm so saddened because these are the same set of people who kept signing whatever they call it, peace party, who have said this, who have said that. Nigerians are very hypocritical. They are too hypocritical. I think we have to allow the law to run its course. And whoever feel aggrieved, so be it. If the security agencies do not come up and start taking action immediately, the consequences will be too much for Nigeria to bear.
Thank you very much, Barrister Shola Ajisafe, for coming. Thank you, Barrister Femi Modamori, for coming. My name is Dimeji Danis, and this is where we end it today on Agenda Setting. Thank you for listening.